say something. Now, not to waste any precious seconds of the time, we want to keep sharp with the time. So, welcome to the second part of our agenda, of our program. Alistair has been so kind to give me the chairmanship of the event. So
it's your idea.
So it's a big responsibility, but it's also a pleasure. So I will also try to be not a chair, one that is keeping all of us on time with our busy program today. So the first presentation that we have in the afternoon is by Dr. Bjorn Oliver Massig. He comes from the Helmholtz Center for Environmental Research in Leipzig, Germany. He's also an alumni of the university, so we're very pleased to see him now with his new role coming back to the university. So Bjorn, please, the floor is yours.
Thanks, Juan Carlos. Yeah, thanks a lot for having me. It's a pleasure coming back to Dundee. And let me just jump in straight to my presentation. A quick overview. So I want to talk about what I think are the main challenges of international water law. I want to quickly introduce why I think we should perceive water security as of regional common concern. And then I want to look at how we can see solidarity, the concept of solidarity, evolving, been developed in other areas of international law, not only international water law. And then I want to look at how this concept of regional common concern could actually be implemented in practice. And hopefully by then I will have said so many, well, intriguing, hopefully stimulating things that we can have a nice discussion. And Juan Carlos, please tell me when I'm running into troubles. So the water security challenge to international law, we all know that water, we're facing a challenge of management of water. We have too little, too late, too little, too much, too polluted water in some areas, but that is mainly a problem of management. But in addition to this problem of management, we're facing a challenge of the disrespect for the international community. We've heard a lot about community, communication, and I think this is one of the major issues we have as international water lawyers, is that our language, the international law regarding transboundary water resources, is not up to its task. And we also heard that the international law is not only about rules and obligations, it really is a language. It's supposed to help states communicate their claims, their rights, their obligations, of course, but it's also a starting point. It's a long-term process. It's not only a treaty that people sign and then forget about it. It's the beginning of cooperation. So when I looked at water security and how it's been perceived by states and how it developed in security studies, and then tried to look at how we should actually impose it in international law, I came across a not surprising challenge that is of maximizing overall benefits versus national benefits. So there's still this well, constant conflict of states not allowing to give up their sovereignty or even limit their sovereignty. They still want to hold on to this national security issue, national resource of water. And they are just worried that their neighboring states gain too much in comparison to their own gains. So we have this concept of equitable and reasonable use, and it has done a lot. I'm not saying it's a flawed concept, but I'm saying it could do so much better if we look at it from another perspective. And this other perspective I'd like to introduce later. And because equitable and reasonable use does not perform as well as it could, we still see that hydrohegemons, so the most powerful countries in the basin, use this flaw and still continue building their own dams without consulting properly downstream countries, for example. And they know there is a risk of compensation being paid later, or like economic feedbacks from other countries outside the basin even, but they take this risk. They say, okay, we still continue on a unilateral basis. And my opinion is then that if we have such a big problem in international water law, that we can't just change it by scratching at the surface. We really have to dig deep and change how we understand concepts and principles of international law in relation to freshwater resources. So as you can see here, what I want to achieve with my discussion is that we look at agreements as a long-term process. As I said, not only a treaty and then we put it in the drawer. We also have to overcome this perception that cooperation over water is a zero-sum game. I mean, you've heard it a lot this week, but we are not getting closer to this overcoming, in my opinion. And I like this quote by one of the famous international lawyers, and he said we should, as lawyers, as international lawyers, we should try to, with our research, with our writings, with our opinions, we should try to overcome this world of egoism and, well, create a world of communitarian. And ultimately, what this world of communitarian should lead to is a perception of sovereignty that includes the obligation to cooperate. And if you agree with me that this would be a good idea, you can think of how do we actually phrase this in a legal sense. So how can we draft something that is more common, that is based on a community? And here I propose this concept of common concern. What it would do is that states, of course, should not cause harm with regards to issues of common concern. So in this example, a transboundary watercourse, we already have this obligation. But in addition to that, it would impose a shared responsibility in overcoming those problems of common concern. And I put the example of the UNFCCC here, the Climate Change Convention, and here you have this concept included in the preamble, and several principles in the convention actually refer to this obligation, which is only in the preamble, but it trickles through to actual obligations. So why do I think common concern is a good idea and not any other of the community concepts that are out there? Common area, common heritage, they look at areas that are beyond national jurisdiction, open access areas, so they don't really make sense in terms of a transboundary watercourse or an aquifer. Community of interest is an interesting one because it shares some similarities with the common concern. Why I think, or why I didn't use it, was that where it has been implemented in a treaty, it was actually interpreted as joint and exclusive ownership. So the states with the Lake Titicaca, they basically said, well, this is not our ownership anymore. We give away all the sovereignty. And I think that this would be too much to expect from states to accept at a global or even regional level. So what does common concern then do? As I said, it is a positive action, or it requires a positive action in terms of mitigation of harm. And it strengthens the general obligation to cooperate because you are supposed to cooperate jointly, not only cooperate in saying, okay, I'm building a dam, this is the EIA, I just conducted, just have a look and tell me what you think. It really puts the whole cooperation, the whole negotiation process on a new footing. Then if you agree with me that this would be a good idea, and it sounds all nice, maybe utopian, who knows, but then you might ask the question, how can we actually move forward? So how can we come to materialize this concept? What are our options? Because I'm looking at it from a regional perspective, I say that we can learn a lot from regional regimes outside of the water box, like in maritime, with maritime issues. The Arctic is a good example where there has been some regional cooperation outside of a global discussion, which has strengthened cooperation and has done a lot of good. So we can learn from issues outside of water, but what I think is desperately needed is induction of ethical issues. So lawyers tend to shy away when it comes to ethics. We try to avoid sometimes even concepts like justice because it is very difficult. It's of course engages, it triggers a lot of debates. So we say, well, we try not to get into it, but I think we have to in order to change the things that are fundamentally wrong with international water law. And if you do that, so if you actually look at what solidarity can do to the regime of transboundary watercourses or water resources, then you will actually challenge the perception of sovereignty. So I think it is a good way forward in order to overcome this whole resource protection versus sovereignty issue. And how has solidarity fared in when it comes to transboundary water resources? Some of you may have heard of this concept of hydro solidarity. It has been developed by Malin Falkenmark, a wonderful lady. So she pushed for this new concept and said we have to overcome this conflict between sovereignty and the protection and sustainable use of our resources. And ultimately what it says is that states are willing to cut down their own freedoms. So they are willing to limit their sovereignty. It was very well received by the water community, but nonetheless it didn't gain traction. So there was no follow-up process. It sort of fizzled out. After a couple of World Water Forums, and no one talked about it anymore. The reason, I think, there are two main reasons. One is that there are competing concepts. The so-called water community, that's basically us. We all work for different organizations, we have different agendas, and we have competing agendas. So one organization is pushing for IWRM, the other one is focusing on human rights, and it's easy for one concept which might help a lot to just fall under the table and isn't been picked up again to the negotiation table. So concepts like nexus approach, they've taken over, and now we're following those and forgot about the ones that might actually be useful. So revisiting old concepts might be a good idea sometimes. And because I'm a lawyer, I think the law was missing in the debate. So it all sounded nice, hydro solidarity, but how do you actually implement it? What is there to gain for states? How should you put it into practice? How do you negotiate something like solidarity? So, and this is what I try to do in the next part of my presentation, is look at how other areas of international law have done that, have implemented solidarity in their evolution, in their development. You've probably heard of the responsibility to protect. It made into the headline news. We all know about what happened in Libya and in Syria. In Libya, it was applied, the concept, responsibility to protect the people in Libya from the outside. So third-party countries helped the people because their own state failed to do so. So it's closely linked to human rights law, to humanitarian law. But if you look at the case of Syria, all of a sudden, there was just weeks after the legal community celebrated the breakthrough of the responsibility to protect, that it had to deal with another blow, that in Syria it wasn't applied. Even though the cases are, well, quite similar, they're not the same, of course. So there's something in human rights, international humanitarian law, where solidarity has trickled through, But it also, of course, depends on the case, and international law, of course, is always political, especially when the UN Security Council is involved. But nonetheless, there's some experience to take home here. International disaster law is also including the concept of responsibility to protect. And if you look at the disaster law, there is no such thing like one multilateral treaty where all the rules and obligations are written down, but you have heaps of soft law instruments, of recommendations, of treaties that do all contribute to this one piece of legal area. And some of those rules I put down here are quite strong. Others are perceived as not legally binding. So the right to offer help, of course, that's an obligation erga omnes. So you cannot refuse the state's offer to help you in case of an earthquake or tsunami. You're also not allowed to refuse those offers without any proper reason. So you can't say, well, I don't like you, I don't accept your offer. So there are rules that are binding, and those rules reflect solidarity. So if one state isn't able to deal properly with a natural disaster, other states step in, help out, and they do that because they feel legally obliged in some cases. International trade law, very interesting field. WTO is claiming to make the world brighter and healthier, and yeah, well, you know that it's debatable whether those things actually happen, and there's a discussion of how the WTO is actually distributing the wealth it manages to achieve. But there are rules in the WTO system that are directly linked to solidarity. And one is the special and differentiated treatment of states. So developing countries are being treated differently than developed countries in some cases in order to show solidarity, to not treat them the same, to sidestep this non-discrimination principle. Then my last point, international environmental law. So this is, of course, where solidarity, I think, shows best in international law. So you have concepts like intergenerational equity, which is deeply founded on the principle of solidarity. We are supposed to conserve our environment for future generations because we are only trustees of that environment. So this whole concept of trusteeship, of conservation of nature, is based on solidarity with future generations. And if you are interested in climate change policy, climate change law, you should have heard of the common but differentiated responsibilities that are included in treaty law. And we don't know what happens in Paris, but I think they will be brought up again and rediscussed and strengthened. Again, this idea of, yes, we have a common responsibility, but we don't have the same means. So some states have to contribute to solving the problem differently than others and help each other out in order to resolve the problem. So a lot of different ideas of solidarity in different fields of international law, but they all have in common that, of course, it's a value-driven concept, and it has this ethical underpinning. And what it does, according to some people, it's a reflection of what we can witness, that we see this move from strictly rules, weighing obligations based international law to something bigger, something value-based, according to Wolfram. Others even say it has reached constitutional status. So in this imaginative international legal constitution, there is something of solidarity that is, well, it's changing the way we interpret principles and rules. I'm not sure if we are there yet, but what I'm saying is that we're definitely going to see a lot of discussion about solidarity in the years to come, and I think that's a good thing. Just quickly, the last couple of slides. What would that mean to have something like a common concern of water security? How would that look like in practice? And I'm not saying that all of those rules we have to reinvent them, because they're already there, and you've heard about them throughout the week. What I'm saying is that it strengthens those rules. So if you look at it from a regional common concerns perspective, equitable and reasonable utilization becomes stronger. All of a sudden, regular exchange of data and information becomes the norm. All of a sudden, having a joint institution is just a legal obligation. So this is, I'm not trying to reinvent the wheel, but I'm saying that we could strengthen international water law by looking at it from a common concern perspective. And the ICJ referred to this community of interest approach in the recent case of the pulp mills, which is, as I said, closely linked to the common concern. And I think this helps to stimulate the discussion. And with my last slide, I also want to stimulate the discussion and your questions, hopefully. And that I'm saying that we are at a point in time where international law is, as I said, not only about weighing and balancing rules, obligations, users, numbers, but we are at a point in time where we see international law as a language that helps to improve the guardians of collective well-being. So international law to something bigger, improving the common concerns of the community. Thank you.
So thank you very much. Definitely, we need new approaches to foster cooperation. So, do we have any questions from the floor to Bjorn? Yes, please.
If you could give a prize to an organization or a group of people or which or part of society, I don't know what it is, as the best applicator of these principles that you are presenting, who do you think it would be currently or historically?
The water center here in Dundee.
But you're not right.
No, I'm not right. Well, it's this is, I think, where my whole idea of regionalization also comes in, because how this community of interest, common concern is being perceived in different regions is very different. So if you look at states in Asia, they would probably not be happy to talk about that, because they can see, well, this is too sovereignty, it's taken away too much of our own sovereignty. But if you look at cases in Southern America, they are a lot more open to these ideas. And the case study of the Lake Titicaca, where they gave away their own sovereignty and said, well, let's manage this lake as what it is. It's a joint resource. It's a joint property even. I think that's a very good example where they went far beyond what I expect to be customary international law in the far future. So it's yeah, some states, of course, can build on stronger relationships, and this is where those concepts happen to be implemented sooner than in other areas.
Please, yes.
So I have two questions. One was about your statement that international environmental law provided the strongest origins for solidarity. And you gave two examples. One was intergenerational equity and the other was common but differentiated responsibility. And I'm not an academic, but it struck me that intergenerational equity is about solidarity between generations, to use your term, but that's solidarity across time. And what is needed here is solidarity across space. And so I'm not sure if intergenerational equity is actually a strong basis. The other point was on common but responsibility. Yeah, I'm not an academic. My understanding is that the concept is that states are allowed to go as far as they can towards implementing their duties. And so I'm not sure if that's the same as saying states supporting each other. What do you think?
Thanks. Well, your first point is correct. I specifically tried to make that in my slides. There are other options, other examples where you could show how solidarity was implemented in international environmental law. The concept of sustainable development, I could easily say it's also based on the idea of solidarity. But so that was just to show that it's not only between riparians now, but that the idea is even to look further ahead or back to say, okay, we are only here for this amount of time, but we have to do the best in order to keep this planet in order. Your second point about the combat differentiated responsibilities. It is true that it has, especially in the climate change regime, led to this, well, we only do as little as possible argument. But I think what will happen, hopefully, in the leading up to Paris, is that this stance by developing countries won't be taken any longer. That they now accept that they have to do something, but still in using this concept, say, well, we want to do something, we agree, and countries like, say, China or India are already saying, well, we do want to cut our carbon emissions voluntarily. So you can see evidence for that. But what they still demand is technical support, financial support, in order to get things going, which is a part of this principle as well. So I think it has some issues, but the idea is good still, and I think the way it will be interpreted soon will help to make it happen. Yeah.
Okay, let's take two more questions together in best interest of time. Owen, and do we have another?
I have a second one, but
yeah, but so one from Owen and one from the back side of the room.
I'm not sure, Bjorn Oliver, if it's a question or a comment, so I don't feel that you have to respond to it. On your last slide, you cite UNECE, and I can't remember the expression that he uses about collective something or other. And I just noticed in the recent literature on this issue of sort of a guardian of collective well-being, international law, and I just noticed that in the current literature on this sort of transition from a law of coexistence to a law of cooperation, a number of commentators rely very much on UNECE, people like Sandrine Marjan-Dubois, a number of these other. And I sometimes wonder, reading it, the extent to which this is wishful thinking, or is it based in observed fact? If you know what I mean. It seems to me to be a kind of a utopian vision of international water law, which we'd all love to buy into. But, you know, I just wonder if sovereignty is as dead as some of these people imagine.
Yeah, no, I totally agree, and I don't want to talk sovereignty dead. My point is that we have to interpret sovereignty in a way that is allowing for more solidarity. And there are several examples, and I try to make some of them, where it has worked. And my point is, if it has worked in humanitarian law, in other areas of environmental law, why can't it work in water law, which is so important? So that's basically my point.
Last question, please.
It's just more of an observation that it's around this notion of cognitive sovereignty, which I think is a very important, flag for us to try to move towards. So let's say we were all so good at what we do that within 5 years we've gone all over the globe and every river system has got a treaty, and it's all reasonable and equitable. In a way, that first of all locks everything into that system. And we already know groundwater, we might have to add that in a bit later. But the real movement of water in the world is not rivers at all, it's food. And you can calculate that more water is used to grow food than anything else. And put the volume in going around the world, and it's not this old historic blue lines on maps stuff. The real stuff is food. You know, Australia, talk to Australia about growing grain and the fact that they stopped exporting it because they want the water. What about South Africa and all this beautiful South African wine in my supermarket here? That is vast volume of water. And, you know, it's calculated that 4 cartels control about 60% of the world movement in water. And they're food cartels. That's what's moving. So, coming back to the point, perhaps we will eventually move away from the idea of cooperative sovereignty, meaning this country on the left and that country on the right, simply because the river goes across, to a much broader definition of that cooperation. You know, when there's a deficit of rainfall in Ethiopia, for example, food aid, well, I calculate that in terms of cubic meters of water. So it's just a water transfer, actually.
Yeah.
And so is all this food, and you'll know, but for obvious reasons. So, you know, if we look at virtual water, not just the blue water, capturing green water, we enter into a different game, completely from the one we're currently focused.
Absolutely. And this is where concepts like benefit sharing, we said earlier, and I think also solidarity comes in, because it's not only about the resource, it's about what you want to do with that resource, and there are other means to help states to achieve that. So,
can I reply very briefly to Morgan's point? You've probably heard me make this point before, but I think it does need to be made, and in this context, because Bjorn Oliver talked about the intersection of international trade law. I mean, what you're talking about is an international trade law issue. This is not an issue concerning international water law as a resource. It's an international trade law issue. And the simple fact is that within international trade law, there are the mechanisms where we could consider the amount of water embedded in a project and the impact of particularly export of commodities that use a huge amount of water. What we call NPR PPMs, non-product related process and production methods, which can be considered under, for example, the GATT Article 20 exceptions to international trade rules, where you can impose, where states may impose import or export restrictions for reasons to do with the sustainable use of a natural resource. That's the language in GATT, going back to 1948. So those mechanisms exist. They're very much underused, but they exist.
Because Australia does that now. I think Spain do not have to report exports from the river basin in Spain. There's a system. You know, what volume of food crop are you taking? So it's coming, and it will come. But I think it feeds to exactly what you're saying. It's not pointing towards a different international regime, but it's what's our view on this in the future.
Thank you. No, I think it's very interesting, and we could continue discussing about these topics for a long time. But in best interest of time, I think we will give a our next presenter is also a very familiar face in-house. She's also ex-alumni of the master's program of the center. Ruby, I always have problems pronouncing your Moynihan. Ruby Moynihan.
Perfect.
There you go. So Ruby Moynihan is a student, full-time student, PhD student of the School of Law of Edinburgh University, but she's also with Helmholtz Center for Environment and Law, and she's also a fellow hydronation scholar. So Ruby, please, the floor is yours.
Thank you. Yeah, so good afternoon. I'm going to present a little part of my PhD research. It's not the whole thing, but just a wee insight into what I'm doing. This is a beautiful picture that I put up just for art's sake. I get not so, oh no, what have I done there? There we go. So there are two overarching kind of objectives that I'm trying to address in my broader research, and one of them is this problem of fragmentation in international environmental law. You guys have already heard quite a bit about this over the week. I think that we're lacking coherence, or at least there are gaps and missed synergies that could happen between different levels of law, water law at global, regional, and basin levels, and also between water and water-related law at, international environmental law, also pan-European environmental law, and water-related instruments at basin level. So that fragmentation or coherence problem is a central problem behind my research. The second overarching issue is, or objective, is to understand the rising role and contribution of regional regimes to water law. And this has come about because, as we've probably also heard throughout the week, the 1992 UNECE Water Convention, well, it's not yet open to all member states, but it hopefully will be quite soon. And this regime is a very interesting one because, actually, contrary to some misunderstanding, it's not really just the European regime. It also has member states from non-EU countries and also from countries who aren't particularly highly developed and have extremely bad pollution problems and are still in that industrial developing phase. So it's quite interesting because it's not just the EU. And since the UNECE Water Convention member states agreed to open this convention up to non-UNECE states, there's been a lot of interest, actually, from countries far beyond the pan-European region, Costa Rica and Iraq, for example. And at the last meeting of the parties for the UNECE Water Convention, I think there are about 30 non-member countries participating. So it just shows there is a great interest in this convention. It's also a very sophisticated regime for a pan-regional regime. So it is interesting, and of course at the same time, last year in August, the 1997 UN Watercourses Convention entered into force, and so you potentially have these two, perhaps global instruments. I'm not so sure they are both global, but anyway, it's certainly worth discussing. And there's been some recent research done. Ali's book's just come out, doing a lot of, and Owen's on that one as well, comparing a lot the UNECE Water Convention with the 1997 UN Watercourses Convention, but I think there's still a bit more work to do. So actually what I'm going to talk about today is just one small aspect of those issues. I'm looking at the ecosystem approach in international law relevant to transboundary river basins, and how implementing this ecosystem approach requires more interaction between different international environmental legal regimes and through the different levels of governance on water as well. So where does this concept of ecosystem come from? Where does ecosystem approach come from? What is the role of international environmental law been? How has international water law responded? What does an ecosystem approach actually add to international environmental law and international water law? And how has the ecosystem services approach emerged from within the ecosystem approach discussion? What are some gaps in international water law relevant to applying that ecosystem approach and the ecosystem services approach? And what is the potential role of regional regimes in general for environmental protection and international law relevant to water? So you've already had 2 or 3 presentations about ecosystems this week, so I'm not going to go into too much overlap. But hopefully I just pick up on some different angles. The first is, the concept of ecosystem is scientifically constructed. So the scientists constructed this concept in the 1930s to help us understand this complex and dynamic interconnected nature and the structural components of ecosystems, the living and the non-living organisms. And of course we know that well, we probably all, of course, don't know, but 10% of the Earth's continental surface consists of freshwater ecosystems, and 40% of the global population is reliant on transboundary freshwater ecosystems. Biodiversity inside those freshwater ecosystems is the most at-risk biodiversity type grouping that we have, so it's a major issue, and the prominent driver of that extremely at-risk biodiversity is land use change, but there are also many other factors like climate change. So how does international law come in here? International law has responded to this scientific construct of an ecosystem and begun producing a legal understanding of the construct. And this has provided the basis for normative development of an ecosystem approach. And this is much broader than an obligation just to preserve and protect ecosystems. There's no agreed definition of an ecosystem approach. How international law of the sea or marine law, freshwater, biodiversity and wetlands legal instruments have addressed the ecosystem approach is different. And it will be interesting to understand the relationship between how those different regimes have addressed it, which we've also discussed a little bit this morning. So I'm really just going to have a look at actually how the International Convention on Biodiversity has looked at ecosystems and the ecosystem approach. I'm not going to go into the other areas of law, I don't have time. So the CBD, or biodiversity regime, is really, I guess, the champion of the ecosystem approach, and that they've driven forward a lot of the development that we now have. Ecosystem itself finds a treaty basis in the convention, so it's in there. And Juan Carlos went through those provisions a little bit yesterday. But the ecosystem approach itself doesn't have a treaty basis in the convention text. Instead, it's this consensus-based process of the COP. It's the Conference of the Parties decisions that have gradually fleshed out the meaning of that ecosystem approach into a system of soft law principles and guidelines, which builds upon previous developments in international environmental law and brings us to where we are today, because it also pushes forward the boundaries significantly. And just on that point, what's interesting about this, when we talk about soft law here in this system, the COPs are intergovernmentally negotiated. A consensus is normally found on the adoption of the COP decisions, and therefore we can say they're quite a strong, soft, non-legally binding instrument helping us interpret provisions around an ecosystem, around ecosystem protection. So these are some of the different COP decisions which are relevant to fleshing out what an ecosystem approach means. And we've already been through those this week, so I don't need to go through those in detail. What then are the key contributions from the CBD regime to an ecosystem approach? What could those key contributions be to international water law? What's different about an ecosystem approach that we don't already have with IWRM or maybe a nexus, although I haven't really considered that? So for me, an ecosystem approach prioritizes conservation and it ensures ecosystem functioning and resilience. It really pushes sustainable use to consider the limits of ecosystem functioning. It promotes connectivity through the multi-layered systems. This is all a little bit similar to IWRM, but not quite. It helps understanding the balance between conservation and sustainable use in an ecosystem approach. But this balance is still very difficult. So it's very difficult to reconcile these diverging ideological standpoints between conservation and sustainable use. It has a very strong focus on equity. So it recognizes humans, cultural diversity as central components of an ecosystem. And it should be a decentralized process. So it should require consideration of Indigenous peoples and local communities, intrinsic, tangible and intangible values attached to freshwater biodiversity. And this interstate dimension is something that international water law could definitely learn from. Ecosystem services under the CBD. So in the process of developing an ecosystem approach, the CBD COP parties noted the relevance and the great work that was done under the Millennium Ecosystem Assessment, which we've also been through. That really, this is this global scientific process that facilitated intergovernmental endorsement of the term ecosystem services. And what does ecosystem services give us? Well, it draws attention to the value of biodiversity, clarifies why prosperity and poverty reduction depend on maintaining ecosystem services. But ecosystem services also raises divisive questions. It's not popular with everybody. And that's because of a whole range of issues, including the moral and cultural acceptability and the effectiveness of pricing and marketing. of ecosystem services, or there are inherent pressures towards privatization once you start quantifying services. And so it's really a challenge to find an appropriate balance between ecosystem stewardship and ownership. There's confusion about the extent, though, to which monetary valuation is actually pursued as a goal under ecosystem services. Ecosystem services is not just about monetary valuation, and it's really interesting. For example of that is the TEEB study, which is it's called the Economics of Ecosystems and Biodiversity. But really, when you look at the types of valuation techniques that are used, monetary valuation is one, but there are many other types of valuations that occur to try and ascertain the value of an ecosystem services to people. Yeah, I don't know whether the humans are the crocodile and the little frog is the ecosystem, or that's an ecosystem in itself. But anyway, because of the science around and the economics around ecosystem services is quite uncertain, it's important, the precautionary principle plays a really important role in this concept. This is really about comparing how the United Nations 1997 UN Watercourses Convention has addressed ecosystem approaches. But I think in the interest of time, I'm not going to go into any detail of that because we've already heard that with Juan Carlos. But I just want to say that reinforce what he said about, the UN Watercourses Convention itself is not so good at considering the ecosystem as a whole, ecosystem functioning, or the process and the services in the way that has been provided by the CBD or the UNECE water regime. And the UN Watercourses Convention is about interstate treaty, and an ecosystem approach demands more of a multi-layered level approach involving non-state actors as well. So, yeah. So now I want to move on to the sort of final but key part of my research, and that's trying to understand the contribution of the UNECE water regime, as I call it. And what I understand by that is looking at the Water Convention and the other UNECE environmental conventions, all the soft law instruments under those and their protocols, and trying to understand that as one comprehensive environmental regime that addresses environmental protection relevant to international watercourses. The ecosystem approach is part of that. And the UNECE was the first forum, actually, where governments agreed on an ecosystem approach in the context of transboundary water. So it has a treaty, the ecosystem approach has a treaty basis in the convention itself, and then, of course, through all the different soft law and technical guidance instruments under the UNECE Water Convention, that ecosystem approach is the components of it are fleshed out by those soft law instruments. The ecosystem services approach, again, is not widely implemented in transboundary river basins around the world. Alistair and Chris have done some really interesting research pointing out the limitations of doing that in a transboundary context, and that includes limitations around equity, property rights, market mechanisms, in institutional capacity and stakeholder participation in a transboundary setting. But also there are issues of scale, agreed joint methodology between scientists, how you actually do this. If you use a different algorithm, you come up with a different set of priorities on which services that you want to support. So it is a very complicated thing. So you definitely need a good collaboration between law and science. Thank you. What I want to understand is, if we understood the UNECE as an environmental regime, could we then better strengthen this developing out of an ecosystem approach? So, final two slides. Future research directions. So this is what I'm working on at the moment. I don't really have any answers, but it's ongoing. Can an ecosystem approach serve to create more synergies itself between water and water-related environmental regimes? What about this concept of an ecosystem approach being a principle of international environmental law? How can an ecosystem approach under the UNECE environmental regime contribute to understanding its development in international environmental law generally? Could an ecosystem approach ever cover the full hydrological cycle? So the larger ecosystem, the trees and clouds beyond the river basin. And the relationship goes both ways, of course. We really need to understand the true impact of the CBD's work on ecosystem approaches and equity in the context of water. Oops, I'm not. Equally, drawing back out beyond just an ecosystem approach, but looking at this UNECE water regime in general, I think that the contribution that the regime has made to environmental protection and international law deserves further recognition. Or is this just simply a regional regime with no real value beyond the regional context in which it was developed? In the whole process of thinking about ecosystems, we always have to remain very healthily skeptical about the ability of this new concept to deliver equity and sustainable use and protection, and also protect the most vulnerable people in the river basin. Thank you. I like the picture.
Very, very good and very interesting topics. Do we have any questions for Ruby from the floor? Everything crystal clear? Is there's already first you and then
how you're conceptualizing region? Are you framing it as scales, or are you using bioregions, or more world regions? How do you superimpose the region on the ecosystem, or vice versa?
Yeah, I'm basically looking at the pan-European UNECE region by member state. So that's not even a geographic region, really, because the US is part of the UNECE Water Convention. Although, to some degree, I forget that. I mean, I deliberately don't address that in a way, but I'm trying to talk about the regime by the member states. Yeah, yeah.
Is the ecosystems approach something related to water, or is it something that you can apply to the conservation or natural elements?
It's definitely not only about water. The ecosystem approach has actually evolved more within the biodiversity protection regime. It's in marine law, it's in Ramsar. You can see it coming through in agricultural law. So water is only one area where the ecosystem approach is developing. Yeah.
So it has been applied to the water law by somewhere else. So I'm not sure that has been applied already.
Yes, but it has developed in a different way in water law, perhaps, and maybe those connections between the other regimes aren't made often enough, although in the last few years there's quite a bit of research that's come up trying to make those connections. Yeah.
other questions? Then we use the prerogative of the chair. So it gives me the impression that you're trying to cut across fragmented silos, if you will, within environmental law and outside environmental law. So using maybe the focus on territories and ecosystems as that way of bridging between biodiversity conservation, water law, maybe even climate change. So in your view, how useful or how not useful is the concept of fragmentation in the research that you are doing?
Well, how useful is the concept of fragmentation? I mean, what I've realized very quickly is I don't really know that it's actually a problem of so much fragmentation or incoherence, and that a lot of the international law that exists that's relevant to transboundary waters is not really in conflict with each other. There's a little bit of conflict. There's conflict between the international law and freshwater and surface water, a little bit. But it's more a matter of trying to ensure that there is a greater level of interaction between those regimes to not miss opportunities for better coherence as opposed to a problem of fragmentation, I think. Yeah.
So, Sarah, please.
It's not quite a question, and I'm hoping it's not too incoherent and fragmented, but I think we're all thinking about ecosystems and ecosystem services and ecosystem approach. The IWRN course last week, I had a little rant at one point about the sixth mass extinction, and it's not funny. So I'm just thinking, you know, we have all these concepts, you know, like sustainable development, which I'm still attached to. I think it's useful for people like us to talk about, and governments, which actually is less useful, but kind of replace, you know, come up with a new paradigm, we turn our attention to the new paradigm. And I'm just wondering if the lawyers and the lawyerly type people in the room think that focusing our attention on it explicitly social and political will be helping us a bit quicker down the solidarity, down the need to deal with the environment as a case of common concern, because it's a bit more explicit when you're talking about services, and any lawyer who does even a little bit of reading will be like, oh my gosh, this is actually really serious, all these political motions, and we'll be like, so I'm having an upbeat day today,
Shall I just, yeah, I mean, I agree. What I think is good about the ecosystem approach is that although you might at first glance think it's about just the environment, it's about much more than that. And that's, I think, where it might have some value, is that it tries to go beyond just the environment.
Sorry, I wasn't using the environment in a just sense.
Yeah, but, okay. Yeah. Yeah, but of course, we always have to be skeptical of new concepts and names, new what is it, new wine in old bottles stuff. I think that the ecosystem approach has quite a lot of potential. For me, what's interesting is to think if some people argue, you know, it could become a general principle of international environmental law, and I wonder, so what? I'm not so sure what would be the difference if that happened, which is something I'm thinking about. I mean, clearly there's a legal argument that if it's a general principle, then you can apply it to the interpretation of treaties without it being in the treaty, and that's a helpful thing. But are we able to do that anyway through what we already have, through sustainable development, precautionary principle, intergenerational equity? Yeah.
Things to think about. Brilliant. Ruby, thank you very much.